So I'd like to thank John for his thoughtful commentary. He said a lot of things that I agree with. In particular, I certainly agree that if what we're doing is deciding between originalism and living constitutionalism or other competing theories, we have to do a holistic evaluation of both sides. And certainly that's not what I do in this paper, because my purpose here is not to try to argue that we should adopt originalism versus living constitutionalism or vice versa. My purpose is to point out a challenge for originalist theory, particularly original meaning originalism, that will be there even if we're 100% sure that original meaning originalism is superior to all possible alternatives. This will still be an issue. In fact, it'll be even more of an issue than it might be otherwise, because then it becomes even more important to try to figure out what the original meaning of particular constitutional provisions is, and political ignorance is a problem in some cases for efforts to do so. Now, John did say a couple of things that I don't fully agree with. Early on, he says, well, he thinks most sophisticated interpreters of original meaning do not take this view that it's what the public thought at the time. I guess this depends on who you consider a sophisticated interpreter, but as I show in the footnotes early on in my papers, at least most scholars think are sophisticated interpreters have in fact taken this position. Akilah Lamar, Stephen Calabrese, Justice Clarence Thomas, Randy Burnett, some others, so Robert Bork. So they have, this is actually a fairly commonly held position. It is possible that some of those individuals said that without fully considering its implications, but the position does seem to be out there. Now, John also suggested that there sort of might be heightened engagement at times when constitutional amendments are at stake, whether, or in the case of the ratification of the original Constitution, when a whole new Constitution is being created. I think that's certainly possible. That can occur. At the same time, the evidence that is adduced in Pauline Mayer's book, most of it, and other sources that John cited, most of it can fall into the category of engagement by a minority of the population, which is much more interested in politics than the average. We don't have survey data from 1788 or the like, so we can't know that for certain, but it's possible. Consider a recent example. There's been tremendous public debate over the Obama healthcare plan and its constitutionality, but when you actually look at surveys of what people know about that plan, the average level of knowledge is quite low. So you can have a lot of debate, even very high quality debate, that's limited to a comparatively smaller number of people, and it's possible that that's what happened in 1788. That's certainly what James Madison thought was going on, and some of the other political observers at a time, maybe they were wrong. It's hard to know for sure in the absence of more data. So this is actually an area where more research will be helpful. It is not my claim that on each and every contested constitutional provision, overwhelmingly the public was completely ignorant. It is merely my claim that there's a good likelihood that ignorance was widespread, and how widespread it actually was with respect to particular issues is a question that deserves more attention from constitutional scholars. In my paper, I've tried to show why, in fact, that question deserves more attention. So on that note, I think I'll stop, and I very much look forward to all of your comments and questions. Thank you so much, and thank you, John, once again.
Very good. Thank you, Ilya. So our first bracket of three have raised their hands, but please feel free to add yourselves for subsequent brackets. The first three are Will Bode, Larry Alexander, and Jamal Green.
My question comes from the old maxim that ignorance of the law is no excuse. I take it there are lots of laws that people are ignorant of, like most statutes, but they're probably at least as ignorant of those as they are the Constitution. We don't seem to think that poses a problem for being some kind of an original meaning person as to statutes, for thinking that statutes should mean what they meant when they were enacted. And maybe statutes are different because they come from Congress, and those are elites, but then even for referenda, again, we sort of seem to think that you can interpret popularly enacted statutory referenda in their original context. So I guess I wonder why political ignorance isn't a problem for those methods of interpretation too, or is it? I guess you're waiting for
yeah, okay. Well, actually, William's comments sort of segue nicely into mine, but mine are in this sort of why I'm not a public meaning originalist, but I am an originalist. And so I'm the, one of the 8 people, I think, Stanley Fish counted in the world who belong to the camp of the original intended meaning version of originalism. And so the problem that Ilya identifies is a problem for the original public meaning version. But the problem, I think, is deeper with that than the mere fact that different people in the public will have different views, and sometimes no view at all, of what some piece of text might mean. The problem is that even if you could find this sort of idealized member of the public, the Gary Lawson Holy
The Jack
Grail.
Larkin member of the public.
Yeah. And you said, okay, what does this piece of text mean? And they might give you a meaning, and you say, well, it means that because you say it means that? Of course not. They don't view the meanings as self-referential there. What any group that is authoring an authoritative text is doing, it has decided upon some norm. It puts the norm down in some form of communication, some symbolic form, which, and its intended meaning is the meaning the uptake in the Gricean term, that it expects the audience, or that it wishes the audience to take from this. So when you ask even the idealized observer what something means, and you say, well, does it mean it because you think it means it, because you're the idealized? The answer would be no. It means it because I think that's the uptake they intended me to have with this piece of text. And everyone could, it could be wrong, in which case there's a failure. There's a failure to communicate what the norm is. But the meaning of the norm is the intended meaning that it had by the people who authored the norm. And so ignorance of the public then becomes a problem, but it's not a problem in terms of finding the meaning. It's a problem in that there's a failure of communication of that meaning.
I want to, I guess, follow up a little bit on something that John said, which is which I think is not unrelated to Larry's last comment, which is this the notion that this is a bigger problem from a normative perspective than in terms of the positive theory of originalism. So it might give plenty of reason not to be an originalist, but doesn't give much reason to doubt what the original meaning of the Constitution is, original legal meaning. And the person who I would have expected to be, well, I wouldn't have actually expected, but it would have been reasonable for me to have expected to be cited is Ackerman, because I think if you think that that public engagement is an important normative consideration in deriving a theory of authority, then well, is there a case to be made for certain subconstitutional norms being subject to much more engagement than constitutional provisions or constitutional norms, and so what does that tell us about what counts as authoritative? Alternatively, even staying within the positive text of the Constitution, can we tell a story based on, if political ignorance is a normative consideration, can we tell a story of a kind of multi-track version, or what Ackerman would might call normal politics versus higher politics, a multi-track version of which constitutional provisions we pay less of attention to and which we pay less attention to, where something like like the 23rd Amendment maybe gets a little bit less attention than something like the 14th. So
I think that's true. Yep, go for it. So I guess I'll take those in reverse order. So Jamal's question is a good one. It's such a good one that I actually devoted an entire article to it early on in my career, where I actually looked at the one period of Ackerman's tree, where there actually is public opinion evidence of how much the public knew, and through some methods, you can actually have some evidence as to whether the public attention during the New Deal constitutional crisis increased compared to what it was before and after. And I think while the evidence not completely clear, the weight of evidence suggests that the level of public knowledge was pretty low, and if it did increase, it didn't increase very much compared to what it was before. It's much tougher to do these measures for 1868 or for 1787 because we don't have survey data. However, your point is well taken, and I will cite both Ackerman and my testing of Ackerman's theory in later versions of this paper so as to sort of square the circle, while also mentioning that we need more research onto sort of the extent of public knowledge and attention in 1787, 1868. I think Altshuler and Blumen's book about political knowledge and political engagement in the 19th century is probably the best study so far, and I have cited it and discussed it in this article, but much more can and should be done. Regarding Will Bodd's question, yes, people say ignorance is no excuse. What they mean is ignorance of a law whose meaning is clear on the basis of considerations independent of your knowledge of them, that's no excuse for disobeying the law. If, on the other hand, we have a theory which defines the meaning of the law in terms of not necessarily your personal knowledge of it, but some group's knowledge of it, and then it turns out that that group or most of it has little or no knowledge, then that is potentially a problem for the theory. Whether it's also a problem for the argument that people have an obligation to obey that law, that's not an issue that I take on in this paper, although it is an important issue. I would say to the comparison of statutes also, at least in the modern era, most statutes, not all, but many, fall into this category I mentioned in the paper. Ignorance is less problematic because they're relatively clear and precise. Where that's not true, you have things like the honest services statute that the Supreme Court has been considering the last several years, then you do get big problems over the question of whether people can really be expected to obey these things. And in fact, the court has sort of swapped down that statute somewhat. Finally, I think Larry Alexander also raised a good point. I hinted at this in the paper, but I should state more explicitly that although I myself am not an advocate of original intent originalism, original intent originalism does, I think, look better on this particular criterion than original meaning originalism does, because with original intent, what you're considering is the views of a small number of well-informed people. Larry's comment also, I think, raises some important sort of philosophical issues about the nature of communication and law. I think those are big, important issues, but I think they're ones that I probably won't handle until another paper, if at all. I may leave them to those more expert in philosophy than I am, including, of course, Larry himself.
I just say two very small points. I very much agree with Will Bowd's point. I think the question, when we come to statutes, people are vastly ignorant of what the statutes are. They're vastly ignorant of how they've come about and the meanings and their ambiguity, and yet I don't think that proposes a real question for the positive meaning of law. I've not heard that. I don't think there's any more reason to think that it poses a huge positive problem. It's maybe a normative problem. It may be that the fact that people are ignorant of these, vastly ignorant, means we don't have very good statutes, and so we should think of even maybe structuring the normative way we create statutes differently. But I don't think it's a positive problem. With respect to Ackerman, I very much agree with, and it doesn't surprise me his findings on that as opposed to an actual constitution-making process, because one of the difficulties with Ackerman's process, you don't know you're in a heightened period, that something special is happening until Professor Ackerman has declared it so. That's very different from something where you actually have the Constitution of 1789 or you have a constitutional amendment announced. And that seems to me a crucial difference.
All right. Well, let me exercise moderator's privilege and jump in on the next three, or start the next three, by asking the question, well, for law to fulfill its society-shaping function at all, we've we've got to have a vehicle for achieving shared understanding. And our vehicle is surely expert legal advice. Sort of, I think it taps into some of what Will was saying, that we deal with the ignorance problem in our society by having lawyers. And, that big ignorance problem has fueled the demand for lawyers and kept us all in jobs so far. And so therefore, aren't lawyers really the solution to the ignorance problem that you're talking about? That if the inventor of the rifle wanted to know whether the Second Amendment was going to cover his invention or whether it was restricted to muskets, he would have gone and talked to a lawyer. Anyway, the others in this group are David Upham and Mike Rappaport.
I wanted to respond to something John was saying about suggesting that there isn't a problem from the standpoint of positive law. Because I found the draft very thought-provoking and troubling in two respects. First, the positive problem emerges from the text itself because it purports to be a popular document, not just in the preamble and in the closing, but even embedded in there that the House of Representatives will be representative of the people. And the problem is significant because the rivals to originalism are far more radical than living constitutionalism. Those people say this Constitution's a joke. It's just popular constitutionalism is impossible because there is no popular consensus that can exist at all. But I'm kind of moved by your article to become more of an original intentist because it seems the answer the founders gave explicitly and implicitly in the Declaration of Independence and the Constitution is representation can happen. You actually can get bodies of individuals who are representative of the great body of the people, as Madison said. And if that's the case, then those individuals who can, in the name of and on behalf of the good people of these United Colonies, do things, verbal deeds, they also can interpret those verbal deeds authoritatively. And not necessarily by their secret hopes or wishes, but what they intend, distinct from wish, by the words they're doing, or they're making.
Okay, so I was going to say that the person who it struck me you probably wanted to discuss, because in a way the points were good ones in I guess criticizing his view, would be Keith Whittington here. Although a couple of comments now sort of question or cut in the opposite direction of the reasons I was going to say that. So if we look at the positive side and the normative side for a second, on the positive side, Whittington is an original intent person, and at least I regard the problems of ignorance to be a much more serious problem for original intent than at least the hypothetical observer type of original public meaning. Not necessary for anyone to have any intent for get an answer for the original public meaning answer, whereas for original intent, people have to know things. So I was going to say, first of all, Whittington would be, as an original intent person, more subject to criticism. And then on the normative side, who would this matter for? And Whittington is a popular sovereignty person. And I guess this would also matter for the supermajoritarian theory that John and I put forward. But I would say, at least on a consequentialist grounds, that the process of representation helps to solve some of these problems. The people vote, if one goes back to the ratification period, people vote in their general values as to whether they think they like this Constitution in general grounds, and then we have representation in the conventions, and people make more detailed decisions. One has an economizing on information through representation that helps to solve the ignorance problem from a normative perspective. From a popular sovereignty perspective, I'm not sure exactly if that's available, how that's available, how much. Now David's comment is, oh, well, popular sovereignty turns into the original intent of the ratifying convention. I'm not quite sure that's right. I suppose it depends on the type of popular sovereignty view one has. At least a lot of the time in reading Whittington, one gets the impression that it's the people as a whole, not just the representative. So with those qualifications, I would say that at least one person to talk about in the piece that raises sort of interesting questions is Whittington.
So briefly, I agree. I should probably talk about Whittington more, and I do cite him a couple of times, but he does sort of occupy sort of an interesting place in the literature in that I've never been able to tell in my own mind whether I think of him more as an original intent advocate or as an original meaning advocate or some combination of both. So I may need to think a little bit more about that question and sort of cash out in a little bit more detail the implications of my argument for his theory. More broadly, I think there may be sort of ambiguity in the idea of original intent in terms of the question of, well, whose intent is the one that matters? And the most common version of original intent is you focus on a small group of elite framers, right? Like the people who wrote the message that were sending a communication, as Larry said. But you could potentially have a sort of more populist, if you will, view of original intent, which makes it look more like original meaning. And that more populist kind of approaching would be more subject to my criticism than the sort of more elitist version of original intent, if you like. Now, Larry asks, well, what about lawyers? What about experts? Can we just delegate this to experts? And isn't that the solution? That sort of the public delegates these details to them. And this suggestion, actually, I do discuss in the paper a bit because it was raised as a possibility in Michael Rappaport's and John McGinnis's sort of foundational article about original methods of originalism. And there I said it's certainly possible that in some instances, maybe even in many instances, the public's view is like, well, we'll let the experts handle this. But I think this is least likely to be the case with respect to sort of important, significant issues that have a normative tinge as opposed to relatively uncontroversial technical issues. Perhaps more importantly, I don't think we can simply assume that, well, what the public thought was that just the experts would handle this. We would want at least some evidence that that was indeed what the public, or most of them, or some of them, wanted to do. Saying it's a genuine possibility. I think it's most likely to be true with sort of things like, I don't remember, who was it that mentioned the 23rd Amendment? Well, okay, Jamal. So with something like the 23rd Amendment, which most people would probably use as a narrowly technical amendment that most people don't care that much about, fine, that might well be the case. With something like, what kind of discrimination is forbidden by the Equal Protection Clause, I think that's a different sort of story. So I think, we delegate to lawyers in our lives all the time, but usually when we delegate them is to accomplish sort of a narrowly technical task where there isn't a lot of ambiguity about what sort of the ultimate goal is in most cases, like, get me off on this charge or help me win my lawsuit so I can get money or something. Very different story when it's, enact a broad, important value of ours in a way that will be, that can be locked in for many years or even decades and centuries. Yes, I think that covers the two or three comments.
Obviously, I think I do have some disagreement with David Upham about the Constitution. I think the Constitution itself declares that it is law in saying that it's the supreme law. So I think it invites the idea that lawyers are going to fill in, that at least when it is used as a rule of law, it will bring in legal methods to understand these ambiguities. And not even the other parts of the Constitution reflect that. The Ninth Amendment is a rule of construction. It may be other things, but it's surely that. And that suggests that this was understood as a legal document when it was applied legally. So I very much like the suggestion that it really would be, at least as a positive matter, people would have understood that in the law court, if the Constitution is going to be used, we were going to use all the resources of law. I understand that there can be important issues addressed there, but of course, in a contractual matter, for the parties to the contract, lawyers' resolutions of ambiguity may be all important, and on that, millions of dollars may be at stake. And I think people generally understand that as well.
Our next trio is Mike Ramsey, Chris Green, and Steve Smith.
I wanted to comment a little bit on the positive side. Because I'm more of a positive guy than a normative guy, so I wanted to focus on the implications for the positive side of originalism, and I tend to agree generally with John McGinnis's comments on that, but I wanted to expand on that maybe a little bit in the sense that I think originalism faces a question about what it means when it's talking about the meaning. And I think it's a question that goes beyond just sort of the question of what the meaning of the Constitution is, but really into what the meaning of words more generally is. But I think that one thing that it doesn't mean, at least to a lot of the more common views of originalism today, is that it means what the public thought it meant. If you sort of took a public opinion poll and surveyed it, and I think you can see that, and then pick up a little bit back to Will's comment here, that if you think about statutes, or indeed if you think about even outside of law, writing outside of law, the question of what a word means isn't determined by taking a public opinion poll to see what it means, to what people think it means. So if there's a statute that uses a fairly technical term within, say, a scientific and environmental area or something like that, which not only do I not know what it means, so my ignorance of law is no excuse, but even if a majority of people have no idea what it means, as is quite likely to be the case, that doesn't mean that it has no meaning. Meaning is generated by things other than what the majority of possible readers or actual readers think. And so I think there's actually I think when you describe originalism as thinking that, you said at one point you said originalism defines meaning in terms of a group's knowledge, and by that I think you meant sort of the whole political polity knowledge. I don't think that's what a lot of people think originalism means, but it may be what some people say originalism means, and it may indeed be what a lot of originalists sort of loosely describe originalism as being about, a public meaning originalism as being about. But I actually think that they mean something that's a little bit harder to pin down, which is a theory of word meaning that's outside of sort of what just a majority of people want, but is determined by, and this may then go to the question of if this is a legal document, sort of what the legal community thinks it means. That's what defines meaning. I think if you think of it, just think of it not in legal sense, but in the scientific area, for example. It's like a scientific word means what people in the scientific area use it to mean, not irrespective of whether a majority of people have any understanding of it. And that's how a majority of people would understand its meaning.
Chris Green?
Well, I had two reactions that are similar to a lot of things that people have said. Basically, imputed knowledge and constructive knowledge. So the first idea is very similar to what Mike Ramsey was saying, that you have a linguistic division of labor. Representatives that they believe things, they know things, they do so in part on behalf of the public. So, qui facit per alia and facit per se, he who acts or another acts himself. It seems like that's one way to go. Other way, constructive knowledge. The fact that it's in a newspaper is really important, not so much because everybody read it, but they could have. If he's going to decorate this bar with the body of my friend, he should have armed himself. If you're going to vote for somebody, if you care, read it. So, I mean, depending on your normative or positive view, it seems like you could go with one or the other of those.
Well, I guess quite a few of these comments are in a similar vein and different, but let's see if I can focus it slightly differently. One of the solutions that you talk about is using elite opinion as, I think you say, a proxy for the general public. And it struck me that that was a little bit ambiguous. As you were describing, it seemed like by proxy you meant something like the elite is typical of the general public, so that their understanding would be evidence of, or typical of. And you made some pretty good criticisms, I think, of that as a solution. But proxy, I think a lot of comments have suggested, might more sensibly be understood in a different way, as something like the public delegates informally to an elite the ability to make the provision and to interpret it and to understand it. They develop it to lawyers, as Laurie says, or to others and so forth. And in that respect, it that would be, I think, maybe a more sensible understanding. And now, just one further thing. Several people then have said, well, that might help with the positive meaning, but it creates additional problems with the normative aspect of originalism. And I'm not sure this is my view, but it strikes me sort of the other way around, that this is something we do in all kinds of areas of life, in politics and other areas. We informally delegate to somebody else the ability to, we do this in faculties, I think, all the time. I leave it to that committee to decide, what the rule should be and what it means. If it comes up at some point, we'll figure out what they thought it meant and so forth. Well, I sort of embrace, or endorse their meaning without ever paying any attention to it. And it seems normatively attractive in that, first of all, you allow the meaning to be determined by those who are most engaged and informed, rather than by the broad mass who may not be particularly concerned or informed. But I think, contrary to what Mike Rappaport suggested, it doesn't seem to threaten democracy or popular sovereignty, because anybody can pay as much attention as they want to, can engage with it as much as they want to. And if they decide not to, it's because they've decided that it makes more sense for them to let these other people, whoever the people are who are engaged, figure out the meaning. So it seems like it captures some of the virtues both of sort of elite expert decision-making and of democratic decision-making or popular sovereignty, while solving more than you allow, perhaps, the positive problem of meaning as well.
So I think these three comments, to a considerable extent at least, focus on the same issue. Well, what about delegation? I did talk about this in the paper after its discussion, and I expand my discussion a bit further, and I would raise sort of several points. So one, I already mentioned earlier, it's not enough to say, well, maybe their view was that they delegated this to the experts. One would want to have some evidence that this was, in fact, what they wanted to do. And as I suggested, this is more likely in the case of sort of narrow technical questions where there's sort of broad agreement on what we want to do, or simply people don't care about it, than on sort of big normative questions which are value freighted. The question of what kind of discrimination is forbidden by the Equal Protection Clause is not simply a technical question that everybody agrees on or most people have a consensus on. Similarly, the question of what does public use mean? What kind of liberties are protected by the Due Process Clause or the Privileged Immunities Clause or any number of other constitutional provisions which are at the heart of our debates? These are not questions where the principal points at issue are sort of points of sort of technical legal expertise, right? The other thing that I would say is, and this I will have to address explicitly in the paper. I have addressed it in some of my previous work on political ignorance, but not here, is this notion like, well, it's enough if people had the opportunity to weigh in. If they chose not to inform themselves, too bad. I think this does not sufficiently come to grips with the collective action problem aspect of this. That, obviously, if I knew, or if the ordinary member of the public knew that what they decided about a particular constitutional amendment would determine the outcome, they would have a strong reason to become informed. However, for most, indeed the overwhelming majority of members of the general public, the chance that they're individually becoming informed will make a difference is extraordinarily small. And that creates an incentive to not become informed, even if you are, in a sense, a good citizen. You do care deeply about, getting the best possible constitution. If you're taking time and effort to become informed, has very little chance of actually achieving that, then you may not do so. And so I think the problem goes deeper than simply saying, well, they had the opportunity to read the newspaper, they had the opportunity to become better informed. This is a point that I've sort of covered in some other work in political ignorance. I think I made a mistake in not thinking that it was relevant here, but I think clearly from your comments it is relevant, and it will be in the final version of the paper before I try to send it out anywhere. So thank you for that.
Okay, our next three are Stephen Sachs, Garrett Epps, and Thomas Colby. Stephen? Yeah.
I really enjoyed reading the paper. And building off some of the comments that have been suggested already, I was wondering if there might be a notion, I'm not quite sure what name to give it, but perhaps a notion of sort of participating in shared conventions that's relevant here. In that, you can think of a question like sort of who is the current pope? And that's a question as to which, for all I know, more than 50% of the current population of the earth is ignorant. They may not even know what the question is referring to. But that's not a question that necessarily admits of a whole lot of variety of answers, because there's a remarkably well-shared convention. There's an enormous degree of agreement on the correct answer to that question. And that's a totally contingent fact, because you can think of times in history where there were a whole bunch of anti-pope candidates, and it wasn't, even if you thought, well, the experts know, the experts themselves might have been divided, or the expert opinion on that issue was radically divergent from various other groups' popular opinion on that issue. That you can have an idea, it's possible to participate in a shared convention, like on the meaning of a scientific word, so long as you agree on who the informed people are. It would be much more problematic. It's one thing, it's fine for something to be a lawyer's word, so long as everyone has a pretty good idea of who's a lawyer. If there were two sort of competing cases of lawyers, each of whom had radically different conventions and that pointed in different ways, that would be much more problematic. And it would be much harder for us to say what the answer is. Then popular ignorance would matter much more. But so long as the populace is largely agreed on who the lawyers are, and the lawyers are agreed on what the provision means, it becomes much easier to say the public is participating in a shared convention whereby a word or institution has sort of technical agreement surrounding that. And I think this is relevant in two ways. The first is it shows that knowledge is not the same as agreement. So you make the point that most people were ignorant of provisions of the Constitution. But I think almost everyone is ignorant of 26 USC 5000A subsection A, even though that's incredibly important, because that, I think, if I didn't get it wrong, is the minimum coverage provision in the healthcare statute. But if you ask most people, what's that? They'd be like, I don't know. If you ask most lawyers, what's that? They would say, I don't know. And they would turn to Westlaw, they'd turn to the books, and thankfully those all agree. And we'd really be in trouble if they didn't. So you can, or in the same way, I could say a sentence that no one has ever heard before, like, my cat is named Ebenezer Wilkes Smith, and everyone knows what the word cat means, or at least there are a certain range of things on which it might mean, even though they've never heard that word before. So you don't need to know about it to be able to participate in the same convention. The other implication of this is that it helps us clarify, I think, what, and maybe I'm wrong about this, but what the people who support public meaning think they're supporting, which I think is, and this gets to Larry Alexander's point, you could say that the conventions along which we should read the Constitution are those relied upon by its authors in order to communicate things to their audience. And that's a sort of intended convention view. Or you could say, no, the conventions that we should rely on are the ones that the audience, their intended audience actually was using. And that might differ in some cases from the ones the authors were using, and that's when we get the failure of communication, when the authors are relying on one convention, the people they're talking to are relying on another, and you can debate which of those two conventions should matter more. And I thought that the people who supported public meaning were largely supporting the latter, the conventions of the audience, as opposed to the conventions of the authors. But both of those, it seems, don't depend necessarily on knowledge. And so long as there isn't too much disagreement between the two, then we don't need to worry over much.
My comment, I guess it's a question, will be kind of short, but the intriguing thing in your paper to me is the idea that there's this subset of constitutional provisions which have no original meaning. And obviously you don't in this paper say, here's how many they are, here's what they are, but I'm just curious whether you've given any thought to how down the road, assuming we buy into your project, how down the road do we decide which those are? And where's the burden of proof?
Thomas.
I just want to speak for just a second to the positive theory of originalism. I think maybe there are a lot of different ways to categorize originalist theorists and try to group them together, but one classic way would be to divide them into groups of three. There's the original intent, there's the original understanding, and there's the original meaning. And I think if one tries to cram everybody into one of those circles, it seems to me that the objections that you raise go mostly only to circle two, original understanding. Those who believe in original intent, what matters is what the people who wrote the Constitution thought it meant. It doesn't matter what the meaning is, what they thought it meant, and the fact that others are ignorant of it is irrelevant. And original meaning, original understanding, usually sort of meaning the Constitution derives its legitimacy from the fact that the public ratified it, sort of collectively, and we ratified what we understood to ratify. And so the fact that we're ignorant goes to challenge somewhat the validity, or at least the strength of that thesis. But original meaning, when people say original public meaning, I think for the most part, most scholars, public meaning doesn't mean what did the public actually think it meant. Public as distinct from some sort of secret or private meaning. And the scholarship has evolved more to the point of speaking of that as generally an objective and largely a hypothetical enterprise. It's more, what would the public have thought it to mean had the public engaged in this issue? And bringing into bear the methods that one would use to determine this, looking at the people who are best expert at this. And I think, again, for those people, it's not that the fact that the public was ignorant matters very little. It matters only that, this thing still means something, whether we all knew what it meant or not. Justice Scalia would say his constitutional originalism is the same thing as his statutory textualism. And as people have pointed out, most people don't know what statutes mean, but they have a meaning to Justice Scalia, and he uses the same theory, or he says he does, to determine constitutional meaning. So I think it's the middle category, the public understanding people who really have to grapple the most with what you have to say here. I guess my concern is just that that's becoming a very small category. In a lot of ways, that was kind of a stopover provision as people started to evolve away from original intent and on their way to more sophisticated versions of original public meaning. You saw people writing in this original public understanding sort of mode, but I don't know who's left in that circle anymore. Keith Whittington may be one. He sometimes speaks in that way. Justice Thomas, yeah, he says things like that, but he also says things that talk about objective meaning. He says things that talk about original intent. He's sort of notoriously, I don't mean this in a derogatory way, but he's unsophisticated in his originalism in the sense that he kind of bounces around a little bit. Greg Maggs wrote a paper recently where he said, I think Justice Thomas just wants to embrace all forms of originalism for a reason, that he believes that the scholars are slicing the bologna too thin, and he wants to step back a little bit from all of that. I'm trying to think who I would put. Kurt Lash is someone who sometimes, some of the language in some of Kurt's work does seem to rely on this notion that we the people collectively understood to have ratified something, but I'm not sure whether Kurt would put himself in that circle either. So I guess my observation is just that it may be that, had you published this paper 15 years ago, you would have nailed a lot of people. Today, there may be fewer people who are afraid of what you have to say.
Well, I'm glad there's at least still one target still out there. But I guess starting with that comment first, I don't know that I agree with you in drawing such a sharp distinction between original meaning and original understanding. I think that distinction does work with sort of language which is very precise, right? And which sort of the only issue is, did you read it? If you did read it, then it's right away clear what it means. So if you read 26 USC 5000, whatever it is, then it's pretty clear you got to buy health insurance by 2014 and so forth. And by the way, when I say that people are ignorant of particular constitutional provisions, I don't mean that they don't know the particular number. In many cases, they don't know their particular thing is actually in the Constitution. This is the equivalent of not knowing that there's an individual mandate, not the equivalent of not knowing that the individual mandate is 26 USC section 5000 A or E or C. I don't even know that. But I do know that there is an individual mandate, and I think that's hopefully the more important piece of knowledge. Okay, so that I did not know, and that is an example of a crime, of a situation where of actual ignorance of a substantive provision as opposed to mere ignorance of its number in the U.S. Code. So I I think some of these questions, again, repeat the issue of sort of conventions and delegating things to experts and the like. I think I said some of most of what I have to say about that in response to earlier question. I'll say more in the paper as I revise it. For now, I would say that, as I think Steve suggested, this delegation may make more sense, maybe more a compelling argument on issues where sort of there's a strong expert consensus, or where when you read the document, it's clear there's a technical term here, which I know is going to be left to the interpretation of the experts. On issues where the experts disagree among themselves and where the nature of the language is such that sort of an ordinary reader might think this is just ordinary use of language, this is less a less compelling kind of an argument. And of course, unfortunately, many of our deepest constitutional disagreements are in fact over the meaning of terms, which are not in sort of the narrowly technical nature, but rather are about the question of what do these sort of broad general terms mean in terms of particular values. So equal protection, due process, liberty, property, commerce, and so forth. And this in turn gets us to Garrett Epps' question. I think maybe I was imprecise in the paper on this issue. I don't mean to say necessarily that there's a constitutional provision which has no original meaning at all, although I don't exclude that possibility. What I more mean to say is that we may not know what the original meaning of it is with respect to a particular issue that's important to us. So I have no doubt that the Equal Protection Clause, for example, has an original meaning of banning at least some, especially severe forms of discrimination against racial minorities. I think it's very likely that even relatively ignorant voters had at least some sense of that back in 1868. On the other hand, there may not be an original meaning with respect to the question of whether it bans discrimination against some other groups that were not much debated at the time, perhaps discrimination against gays, maybe even discrimination against women, although Steve Calabresi's recent paper does provide some evidence on that. And so in the paper, while I don't give you a list of the places where there might not be an original meaning, I do give you two places where sort of the Sherlock Holmes out there should be especially likely to look. One is sort of the application of broad general parts of the Constitution to specific controversies, and especially specific controversies which were not much debated at the time, but which maybe became important later, things like abortion, discrimination against women, the application of the Commerce Clause, say, to things like environmental effects, the application of public use to takings with respect to forms of property that were not as significant at the time of the founding as they are now. This are just sort of some examples from the paper and some off the top of my head. I think any constitutional scholar can probably extend this list, but in this paper, my purpose is to set out the general nature of this problem and how it would apply to particular issues. It's possible I should extend the paper and say, well, here are like 5 examples, but I worry of making the paper primarily about those 5 examples. I think it may be that I should save the examples for the next paper, or hopefully for people who may want to follow up on this project in their own work.
So the next 3 are John McHale, Rodney Smith, and Mark Tushnet. And we've got some people who want to serve up seconds. We may have time to get to them. But if anyone else wants to do a first round, let me know. Yes, Kurt. Okay, so John McHale. We're probably not going to have time, actually, for seconds, actually, yeah. But anyway, these 3, John McHale, Rodney Smith, and Mark Tushnet.
So I'd like to thank you very much. I wanted to make a couple comments that are just kind of amplifications and restatements of what have been said, but maybe slightly more pointed. It seems to me that you might want to disaggregate the question of the problem of legal ignorance from the problem of political ignorance, because it seems to me really what is at issue here is something that Mike Ramsey alluded to. A rational person who reads a scientific text and comes upon terms that are technical, quark, spin, valence, and the like, ought not to fill in the meaning on his or her own, but to recognize that at that point you really have to defer. There's a technical meaning there. Usually those terms are surrounded by plenty of words that have ordinary language meanings, and so you can kind of move along and identify which are the technical legal terms. And it seems to me the Constitution clearly has some terms which were understood at the time to be technical. Vest. What does it mean for a right or a power to vest? That's a legal term. Privileges and immunities, necessary and proper, executive power. I think that just focusing on which terms in the Constitution are arguably technical legal terms would sharpen what it is you're saying. And then a couple other points here. I think it's important to bring in some historical context. So it shouldn't be, I think, forgotten that most of the Constitution was written by two committees. And the personnel of those committees is relevant, I think, to this question that we're having. We know that 3 of the 5 members of the Committee of the Detail became Supreme Court justices. A 4th became the Attorney General. The people who wrote the Constitution were the best lawyers at the convention. I think that's a safe statement. And it's just reasonable to think that that matters. When they were writing the legal technical parts of the Constitution, they were writing a document that they anticipated that they, more than anyone else, were going to be most likely to construe. I think that's important. And then the last point would be to suggest that you might want to take a step back and also think about this problem of legal ignorance more globally. So not so much of a clause-bound inquiry, where we look at particular words or clauses, but to step back and say, there are other technical aspects to the Constitution, like this question of whether the Constitution is a contract or an act of incorporation or some other legal document. That mattered during the ratification debates to several issues, and it was clearly something that was debated, but it's not the kind of thing that is there on the surface that a non-lawyer or someone who's not attuned to is going to get as the meaning of the document. But it was clearly an issue that was relevant. So that's a kind of an amplified problem of political ignorance or legal ignorance that I think you might want to think about as well.
Okay, and another 2 questions, please keep them very brief.
You may really just be saying this is for you all to decide, but I really want to know who your public is. Then we can know, once we know who your public is it the people who are voting? Is it the people who are reading the newspapers? Who's this public that we're talking about being ignorant? And what is their role? What do they conceive of their role to be? And it occurs to me that that public and the elites, if you will, may have, interestingly enough, in the period as to the Constitution itself, have had some confluence in terms of what they considered their role to be, and that it was in some ways representative, that the Madison thinking that, as Martin Diamond and others have said, what he's thinking is he's creating that they're going to give it back to these ratifying conventions, and then the people will do what the people do best. That electorate, that may be your public, they will elect the best that they can and let them then, and defer in many respects to them. And I think the work of Gordon Wood informs this to some extent. There's this slight period of time, at least according to Wood, where he would believe that the elites really saw themselves in a different way and saw their role between this public and themselves to be different, for example, than is the case when we turn around and get to the 14th Amendment. And then what's the significance of what this public thinks their role is, and what the representatives or the elites then believe it to be, and is there some kind of confluence?
I'll have a chance to say some other context.
Yeah, so as I think you see in the paper, different interpreters of original meaning conceive of the public in different ways. I sort of had assumed that the people would just say, well, it's what the public thought it was, that they meant sort of the public in terms of the electorate, right? And I think that is it is perhaps a question about sort of the original meaning of the scholarly text that I've been reading, but I think that is sort of the most reasonable interpretation of what, say, Robert Bork, Hugh Lamar, Randy Burnett, and others had been saying. There are others who give a clear definition of what the relevant public is, like Jack Balkin, Gary Wasson, and so forth, where they say what's the hypothetical informed person, which is a different kind of a public, maybe even a public that doesn't exist in the real world, but it's just a sort of artificial construct. With regard to John McHale's comment, I think the nature of the 5 people on the Committee of Detail, this matters enormously, I think, if you're an original intent person. I think it matters much less if you're an original public meaning person, because obviously the ratifiers and the general public, they didn't know who was on the committee, I think, who had drafted these provisions. And so maybe they had other reasons to believe that certain things were technical terms that would be left to the interpretation of scholars or lawyers and so forth. But as I said earlier, this will vary tremendously from term to term, and sort of unpacking some of that variation is something that I intend to do in the later drafts of this paper. And my general thought on this is, yes, there are certainly some things that when a lay person reads them, they say, yeah, this is bill of attainder. That's some like weird lawyer word that probably left to the lawyers to interpret. On the other hand, when you see commerce or equal protection or property or liberty, the press and so forth, these are sort of ordinary terms that the ordinary reader will tend to interpret in terms of their own values and the like, and therefore I think that there's a large number of terms in the Constitution, many of which have to do with the most highly disputed aspects of it, both at the time of ratification to this day, where I don't think the answer is going to be, well, these are sort of phrases whose interpretation the public wanted to delegate to the lawyers. I see Michael shaking his head. I think there can be disagreement over this, but I think at the very least I can make a pretty good case for my position on this, and I intend to do so as this paper gets further revised.
Jumping quickly?
I want to just jump in. I do think it is, and maybe this is a slight disagreement here with Ilya, but more of maybe a response to the idea that there is this dichotomy between legal terms and other terms. I think in a document which is entitled a legal document which is going to be used legally, there are legal conventions shot through it, and that I think may be one of the differences about how meaning is cashed out in a legal document.
Well, sadly, we have to stop. Thank you, everyone. Yeah.
Thank you.